Hello and welcome to yet another fabulous show, talk show with experts. Manato unnaru mana expert Rebecca Chen garu. Rebecca, thank you so much for being on the show today, Andy.
Thank you for having me.
All right. For the folks who are watching, call our expert on 1-833-882-8872. The number again is 1-833-882-8872. Watch us on Yup TV, Facebook, YouTube, Sling TV, World BBTV, and Dish Network. All right, this is a pretty interesting topic, Rebecca. You know, everybody is always concerned about, you know, H-1Bs and the extensions and stuff like that. So let's talk about that this week. H-1B extensions beyond the 6 years, and you know, we're going to talk about the laws behind that. Some of the things that they need to watch out for, some of the things, the do's and the don't do's at that point. You know, what are your recommendations? What are some of the things that they can get an early start on, or you know, not do while they're here in order to not jeopardize their chances? Please go ahead.
Definitely. Yeah. So as most people are probably aware, the H-1B is limited to initial 6-year period. The best way to make sure you are prepared to extend it beyond those 6 years is, as Rahul has mentioned many times on this show in the past, is to start your PERM process as early as possible so that you can get the I-140 before the 6th year. Most people are aware of the I-140 will give you a 3-year extension beyond the 6th year, and the best way to make sure you have that I-140 by that time is to start the PERM early on. Even into the 3rd year of your H-1B, you should be thinking about that because of how long PERM processing times are taking right now. What people probably are not as familiar with, or that we don't use as commonly, but which is also part of the H-1B extension law, is that if you aren't able to get your I-140 approval by the end of your 6th year, there is another provision that allows you to get a 1-year extension. So I-140 approval is best because it will get you a 3-year extension beyond the 6th year, but you can get a 1-year extension beyond the 6th year if your PERM has been filed and has been pending for at least 1 year, or will be pending for at least 1 year by the time you reach the end of your 6-year limit. So we haven't had to utilize that provision quite as much in the last few years, but we are actually starting to use it more just in the last 1 year or so, I would say. The main reason for that is the PERM processing times, because it has just been increasing and increasing. It is pretty much at 12 months now. It looks like it might get more to 13 months, where based on the approvals that we're getting in our office, the processing times that we're seeing are like edging past 12 months. So because PERM labor certifications are taking so long, there are a number of cases for H-1B extensions where we've had to go with this 1-year extension rather than the 3-year extension. And not as many people are familiar with that, but it is something useful that will allow you to at least remain in the US for an additional year, continue working. You don't have to relocate or switch to another visa status. And during that 1 year, you can hopefully get the PERM approved, get the I-140 approved, and then your company would just need to file kind of an additional extension before the end of that 1st year. A couple of questions that we usually get about that 1-year extension rule is, do I have to wait the whole 365 days for my PERM to be pending before I can apply for my H-1B extension? And the answer is no. As long as the filing date of your PERM is before you have completed the 5th year of your H-1B, and we provide a copy of the PERM filing to show when it was filed, we can request the H-1B extension even before, you know, even if your PERM has only been pending for a few months. If based on the filing timeline, we can show that it will be pending for at least 1 year by the end of the H-1B 6th year, we can file the H-1B extension earlier and request that 1-year extension.
Okay, gotcha. And Rebecca, what are some of the don't do's or the don'ts rather at this juncture?
Yeah, definitely the main thing to avoid is waiting too long to plan out how you're going to extend your H-1B beyond the 6th year. So I would say definitely by your 2nd or 3rd year, you should know whether your current employer that you're working for at the moment is planning to sponsor your perm or not. Don't, leave it longer than that, because if you're getting into the 4th or 5th year now, because the perm from beginning to end is at least a 2-year process now. So it's getting too late if you're waiting to the 4th year. At least find out by the 3rd year whether your current employer is going to file the perm. Because if not, then you have to strategize from there, either potentially switching to another employer who will file the perm for you, or there are actually a couple of self-petition options that we've also been utilizing more in the last couple of years, sometimes for the purpose mainly of getting the extension beyond the 6th year. One of those is the EB-1A, the Extraordinary Ability. People are probably familiar with that because it's the very high standard. You have to be very well qualified in your field. But if you don't meet that, there is another self-petition green card option called the National Interest Waiver. It is also an I-140. It's in the EB2 category rather than EB1. So if we've been looking at that more and more for people, especially in a situation if their company is not willing to sponsor the perm for whatever reason. The National Interest Waiver, you still have to be pretty highly qualified. Either you have to have a master's degree or a bachelor's degree and 5 years of experience. But you don't have to, have the level of credentials that an EB-1A extraordinary ability person does. The main thing you have to show is that your work is somehow benefiting the United States national interest. So some examples that we've done are like people who are working in renewable energy. Actually, anything in AI or tech is very a good basis for an NIW as a result of the Biden administration's executive orders about AI and emerging technologies, new and cutting edge technologies. So work in those fields could be a good basis for filing an NIW. So if you're approaching your 5th year, what we have done in some cases is if the person knows the company isn't going to file the perm, or maybe they've started the perm, but they won't get far enough along to file it before the 5th year, we sometimes will recommend to that individual, go ahead and file your own NIW. You can still let your company process the perm. They can still finish that out. There's nothing wrong with having the perm ongoing by your employer and at the same time you personally file an NIW. You can have both pending at the same time. That's fine.
And what's the price point kind of that people are looking at when they're filing through this, Rebecca?
For the national interest waiver, for the attorney's fees, that would depend on each attorney. So it's best to kind of contact the attorney for those legal fees. But the filing fees, the DHS filing fees, right now they're $700. As of April 1st, they're going to increase to, I believe, $1,015 will be the government filing fee. One good thing is that for the national interest waiver, there is premium processing available. It's 45 days instead of the normal 15 days. So premium processing is about $2,800 now. But there are a couple of situations where if you feel like you have a strong NIW case, a very strong one, then you probably do want to do premium processing, because then you can get the I-140 approval and get a whole 3-year extension. If you feel like you might not, you might kind of have an iffy national interest waiver case, it might actually be in your better interest to file in regular processing, because you would file it before you're entering your 6th year of H-1B, and what you want is for it to be pending as long as possible so that you can get that 1 year pending also applies to the NIW. And so you want it to be pending for a long time so you can get the H-1B extension. So yeah, in some cases we will recommend actually regular processing for the NIW. If they're filing it mainly for the purpose of getting that H-1B extension, sometimes that's the best strategy.
Rebecca, who can they contact at the Reddy Newman Group in order to sort of at least see if the process can be started, if they even qualify for this,
Mhm.
who can they reach out to?
Yeah, there are a couple of attorneys at our office that are very specialized in national interest waiver. One of them is 𝐀𝐓𝐓𝐎𝐑𝐍𝐄𝐘. He's one of our associate attorneys. I also work on NIWs. Ryan Wilk in our office also works on NIWs. So any of the three of us, I would say particularly Kareem has probably filed the most in our office.
Okay, and we're going to try and so link his email or the company email at the end of the show, so that any of you who are interested in this process can definitely contact the Reddy and Newman group, at least to see if you can get, if you qualify for this, if you can get started, because this is an amazing piece of news. We didn't know about this national interest waiver. And the reason I was asking you about the fees was because when we talked about the EB5 category of things,
oh no, it's nowhere near the
right? So
yeah,
which is why I was sort of asking a question about what can people expect in terms of the filing and everything. So it looks like it's pretty much on par with your regular H-1Bs or I-140 filings and stuff, which is great.
Yeah, probably a little more than a normal perm-based I-140 because there definitely is more argument that goes into proving how your work relates to national interest. I would say generally it's
True,
probably...
but it's not $1 million, so we're happy.
Yeah, definitely not on the EB5 level.
Gotcha. Thank you for that update, Rebecca. Anything else you'd like to add before we start taking our callers today?
Not right now. Oh, actually, one thing I did want to mention is in that situation, if you're going for a 1-year H-1B extension based on a pending perm, sometimes we run into the situation of what if the perm is denied during that time or before you can even file the H-1B extension. So we do also have strategies to work with that. If the company is willing to, what we have done is file an appeal of the perm denial if the company is willing to file the appeal. So a pending appeal of a denied perm is essentially the same for H-1B purposes as a pending perm application. So, and then perm appeals notoriously take years. So it will be pending for a couple of years. So it should be pending long enough to at least get the H-1B extension. After that, it will be a matter of strategizing timing, because if it's not a strong perm case, if you have a feeling the appeal is not going to be successful, then what you want is for the company to actually do a new perm. They would need to withdraw the appeal in order to do a new perm. And so there's some very careful timing to work out there, but it can be done. So even a perm denial is not necessarily the end of the road as long as it was filed early enough.
Gotcha. That's amazing news, Rebecca. Thank you so much for that. And on that note, let's take our first caller for the day. Okay, caller with number ending in 2558. 2558. We're ready for you now. Hello?
Yeah,
caller with number ending in 2558. Hello, sir.
Yeah, good evening. How are you?
Good evening, sir. We're good. Thank you for calling us. Yes, sir. We can hear you, sir. Please go ahead with your question.
My question is, if I'm on the adjustment of status and if there is a change of employment, so what precautions I have to keep in mind, and is that 60-day period applicable to me or no?
So technically not. So when you are working based on a pending I-485 and you're looking to change jobs, the baseline requirement is that your I-485 has to have been pending at least 180 days. So 180 days from the I-485 receipt notice date. After that, then you can change jobs without jeopardizing the I-485. Then the main other requirement is that the job that you're going to is same or similar to the job that was in your I-140 petition. Those are the main requirements. After that, we usually recommend a couple things. So one thing that we recommend is to make sure that the I-140 that your I-485 was based on is approved. If it's still pending for some reason, Technically, you can still move to a new employer, but there's always the danger that the original I-140 petitioner will withdraw the pending I-140 before it can be approved, which makes the I-485 a bit more difficult. Another thing that makes it easier to move to a new employer is having the EAD, the valid EAD. If you don't have the EAD, technically you can still move to a new employer, but then you'll need that new company to do an H-1B transfer. So an EAD makes it easier, but it's not absolutely necessary. The 60-day grace period only applies to people on H-1B status. So one thing that people are not always aware of is technically there isn't really a grace period for having no job offer for purposes of the I-485. For the I-485, there's supposed to be continuity of a job offer from the time the I-485 is filed until you get the green card. There's actually zero grace period for being completely unemployed without a job offer. That doesn't mean that you can't be unemployed. So that continuity means you always have a job offer. Even if you're not actively working, you always have to have a job offer in hand that is same or similar to your I-140 approved position. So some ways to kind of make sure that you don't find yourself in a situation where you have a job offer gap is one benefit of being on the EAD is if you have the valid EAD, you can be self-employed. So self-employment can be your job offer if you set yourself up as a contractor or set up your own business. Then in the event you are laid off from one of the jobs, you can just become self-employed, and that's your continuous job always being there. Or if you have a spouse who has an EAD, they can set up a company and employ you. If they do that, they do have to, you should be on payroll. You should, it should still be a 40-hour job, 40-hour-a-week job full-time. But those are some of the ways that you can kind of prepare for a situation where you might be laid off or out of a job while you're on the I-485 EAD.
And if I'm having the H-1B also, which is getting expired later in the year, so is it advisable to renew the 485 or H-1B or move to 485?
It's not absolutely necessary to stay on H-1B, and sometimes it can actually, if your priority date is one where it's not going to become current, it's not expected to become current anytime soon, actually trying to stay on H-1B, yeah, trying to stay on H-1B.
2014.
Okay, yeah, it's still expected to be, yeah, because it's still in 2012 right now. If your plan is to be on H-1B for the whole time until you get the green card, that can actually sometimes be more risky because it's going to be a number of years, unfortunately, unless something changes in the law. And you're more at risk of going out of status somehow or running into non-compliance on the H-1B, and that can actually jeopardize your I-485 approval. Whereas if you just go on the EAD, it's very flexible. You can change jobs easily. The company that's employing you doesn't have to, file amendments every time you change work locations. You don't have to deal with visa stamping at the consulate if you have the 5-year advance parole. So actually, it can be less risky to just move on to the EAD advance parole, especially if you have the 5-year combo card. The only situations where we recommend that people maintain the H-1B is more for dependents. Like if you have children who are nearing 21, they need to stay on H-4 until they can switch over to F1 status if they're not going to get the green card before they turn 21. And so for that purpose, you would need to stay in H-1B. But barring that or some other kind of like criminal issues that could make the I-485 be denied for any reason, there isn't too much reason to really stay on an H-1B.
Yeah, children are covered under the SESPA with the filing date being current. So both are 21 and above. So that is, will there be any implication if I go with 485?
Sorry, you mean when your priority date becomes current, what happens?
No, if I switch to 485 and I have dependent who are about 21, so will that impact in any way if I'm not on H-1B?
If they have moved over to F1 status, then there isn't really a need after that for you to stay on H-1B. But if they are still in H4 and it is expected that they won't get the green card before they turn 21, then they will need to switch over to F1 student visas. And in order to do that, they have to be in H4 status at the time they are like 19 or 20. So yeah, just depending on how old your kids are.
They are not on
Sir,
no, they are not on H1. They are on H4. They are beyond 21 now, but they are covered.
sir, sorry to interrupt you, but this seems like it needs a lot more conversation. So perhaps you can probably contact this company or another lawyer at a different time, because it seems more like you need an adequate amount of time with an attorney to sort this through. So we'll try to take some other callers. That way we can give everybody a chance to ask questions as well. Sorry to interrupt that. Thank you, sir. Thank you so much for calling us. All right, let's take our next caller. Okay, caller with number ending in 9134. 9134, we're ready for you now. Hello?
Hi, Nitya. This is Preeti here.
Hi, ma'am. How are you?
I'm doing good, thank you. Yeah, I had a question about visa stamping in India. So I wanted to know if there is still this issue waiver program applicable for H-1B, visa which is expired.
Yes. So if your most recent H-1B visa expired within the past 4 years and you meet all the other requirements of the interview waiver, those are listed on the consulate's website, then you're still eligible for the interview waiver. Yes, the program is still in place right now. And actually, when you are applying or filling out the application online for the consulate to schedule the appointment, filling in your information, the system now kind of automatically checks if you are eligible for an interview waiver, and if so, they'll kind of automatically put you for the line for the drop box.
Okay, cool. Just to follow up with my visa got expired last year, but I just recently changed my job with a new employer. Will that kind of affect me not be eligible for the waiver?
No, it shouldn't. If it's in the same visa class, if it's still an H-1B, even though it's a different employer, it should be fine.
Okay, cool. Yeah. Thank you.
Thank you, ma'am.
Yeah.
Thank you so much for calling us. All right.
Just last one question. What is the minimum days I have to wait to go for H1 stamping? I mean, for India stamping?
Oh, it varies quite a bit. So I don't know off the top of my head. From what I've heard for H-1Bs, it's about 2 to 3 months out, but it can vary depending on the exact consulate. There is a government website. If you Google visa appointment wait times, and then there's a State Department website that should come up, and look at the State Department website. It allows you to type in the city of the consulate, like Chennai or Hyderabad or anywhere else you're planning to go, and it will pull up the approximate wait times as of now for the different visa types like H, L, F1, B1, B2. It will give like 100 days or 50 days for the different visa types. So I would definitely consult that for it's not always exactly accurate. They don't always update them as much as they should, but it will give you a rough estimate.
Okay. Thank you, ma'am. Thank you so much for calling.
Yeah.
All right, let's take our next caller. Caller with number ending in 8868. 8868, we're ready for you now. Hello.
Hi, ma'am.
Hi, sir.
Hi, Cynthia, ma'am. Can you hear me?
Yes, sir, we can hear you, sir. Thank you so much for
Yeah,
calling us. Go ahead with your question,
Yeah.
sir, please.
Sure. Thanks for taking the call and all the help. So I have a green card EAD, and my parents need some help. They met with an accident, and I need to be in India for some time. So just want to know, like, what is the period that we can be outside of US and then come back using the EAD card. I have the 5-year validity one.
Okay, and you have the advanced parole also, the EAD AP is a combo card?
Yeah. Yep.
Okay. Okay, so technically there isn't an amount of time that you're required to come back after an overseas trip while on an EAD or advanced parole. However, like we mentioned earlier, there's always the requirement, in order for your I-485 to remain pending, there's always the requirement for there to be a valid U.S. job offer, at least a job offer. So it will kind of depend more on your U.S. employment, on whether your employer is willing to let you work remotely from abroad, or to if you need to take an actual leave of absence and not be working, if the company in the U.S. is willing to say that we still have this job open for you, and it meets the requirements of being same or similar, that they're basically keeping the job open for you even though you're not actively working at the time, then yeah, technically that's fine. So it's kind of mainly limited by that, how much time the employer will let you be outside the U.S.
Sir, if I may
Okay,
ask,
great.
are you working as a contractor or as an employee?
Full-time.
Full-time. So, Rebecca, if you
An
don't mind,
employee.
I was working as a full-time employee on my EAD. I did have a similar situation, and I remember taking the family medical leave, FEMLA,
Yes.
as they call
Yeah.
it. So
Oh,
that
great.
basically gave us the option of keeping our job safety while needing to travel on like a medical leave thing. I had to take care of my parents at one point. So I had to go to India, and I think they had like a 3-month period where your job is safe. So the EAD, and like Michelle said, as long as you have the advance parole that is valid, as long as you take care of this FEMLA thing, I think you should be okay to get time off, paid time off, or at least, unpaid time off, but keep your job
Awesome.
safe. Yeah. Sorry,
Perfect.
Rebecca.
Yeah. That's a good
Oh,
idea.
no, yeah, that's a good point. Yeah, I believe it's 12 weeks usually for most
Yeah, it's 12
companies.
weeks. Yeah,
We're
so I was there
certified.
for about
Yeah.
3 months as well, and could come back, keep the same job that I did, keep the same salary that I did. Just had a valid advance parole, and everything was fine.
Awesome. Yeah, this is a good point. Yeah, thank you so much. Really appreciate it.
All the very best, sir. Hope your parents are okay. Thank you so much for calling us. Yeah.
Thank you, ma'am.
Let's take our next caller. Okay.
Thank you.
Thank you. Okay, caller with number ending in 9384. 9384. Please go ahead with your question. So please press *6 to unmute your line. *6 to unmute your line.
Are you able to hear me?
Yes, sir. Hi, sir. Thank you for calling us.
Hi,
Go ahead, sir.
Hi, I have two questions. First is about the priority date. So Rahul sir, my priority date is in February of 2014. Have you seen the recent data from USCIS, how the backlog is looking, and if there is any chance that in October of 2024 or October of 2025, it can go current? That's the first question. And the second question is about advance parole. So do you have any idea if National Benefit Center is giving 5 years advance parole extension?
Okay, yeah, so for advanced parole, pretty much any advanced paroles that are being issued now are always 5 years from our observation. Ever since they made that policy change at the end of 2023, like in the fall of 2023 when they made that announcement. Since then, all advanced paroles that have been issued from what we've seen have been 5 years, even if the I-131 application was originally filed before that announcement. So that is one good thing, that all new advanced paroles being issued are pretty much routinely all 5 years. For
Okay,
your first question,
it doesn't have to be filed along with the EAD application to be
No.
eligible for 5-year extension, right?
That's right. Yeah. So it can be issued standalone
And-
advanced parole as that one
Yeah.
page for 5 years.
Okay, and the same is still valid for all the EAD extensions that you are seeing recently from NBC, that they are also being extended for 5 years?
Yeah. Yeah. If it is based on a pending
Okay.
I-485, EADs and APs are being issued for 5
Yeah.
years.
Okay. And yeah, if you can please answer the other question about the priority date, how is the backlog that USCIS has for EB2 and EB3 at this point?
Yeah, unfortunately, the outlook is not great unless there is a change in the law where, or a change in USCIS's policy where they, for example, stop counting family members or some of the other recommendations that we've been making. Unless there's some kind of significant change like that on the government side, if the visa bulletin rate kind of continues at the rate that we're seeing so far, we don't see the priority dates reaching 2014 for a number of years, unfortunately. Yeah, because right now, even the non-Chinese or Indian countries are getting backlogs, which is always a bad sign for the countries that are backlogged. EB1 is getting a backlog, which is, a bad sign for the EB2 and 3 categories. And it doesn't seem, based on, the data and what we've been hearing from the government, that there's going to be much change there, unless there is, like we said, a change in policy.
Okay. Sorry, can I also ask you one more question, if you don't mind? And my question is regarding my daughter, who is a high schooler at this point. She's on a H4 visa and her age is logged in CSPA. So what I want to ask you is that does law allows the primary applicant to stay on H-1B while their kids can use EAD for their college admission and for, internships and things like that? Or they are just allowed to be on H-4 being a dependent?
No, for the dependents, they always have the choice of being on H-4 or just using their EAD and advanced parole. For you, if you are using the H-1B, then your daughter has the choice of being on H-4 or using the EAD AP. But if you go off of H-1B, then she only has the choice of using the EAD. So H-4 is not an option for her if you are not on H-1B. But it sounds like it's not necessary in this case. If her age is locked in and you're sure, based on the priority date calculations that her age is locked in, it sounds like it's not necessary in your case. But if you want to, you can continue on H-1B.
Okay, I got it. Yeah, thank you very much. Thank you. Yeah, thank you very much.
Thank you so much for calling us, sir. Appreciate it. All right, let's take our next caller. Okay, caller with number ending in 7413. 7413, we're ready for you now. Hello? Caller with number ending in 7413. We're ready for you. Hello? Okay, let's try to take another caller. And in the meantime, a question for you, Rebecca. This is from Kiran K. Says, under cross-chargeability, do we need to file an I-140 separately for a spouse as well? And can we go out of the US while a 485 is pending?
Yeah, so for cross-chargeability, it's not necessary to file a separate application for the spouse. For the I-140, it would just be filed as normal by the employer for the beneficiary. And then when the priority date is current, the beneficiary and the spouse will each file the I-485 together. So each of them will have an I-485 in their name, but they'll be filed together. And in that I-485 application is where you include the request for cross-chargeability. So make sure it's, a big, brightly colored sheet on the top of your I-485 application that says that there's cross-chargeability due to the spouse's country of birth so that the mailroom doesn't reject it. But yeah, that's pretty much all that's required to use the cross-chargeability. And then as far as traveling while the I-485 is pending, it's that would be the same as kind of any other I-485. You just need to make sure you have the advanced parole in hand, or if you are traveling when you don't have the advanced parole in hand, then when you depart the U.S., you have to be in valid H or L status and then come back in valid H or L status in order to not abandon the I-485.
Okay. Thank you so much. Let's take our next caller. Okay, caller with number ending in 7413. 7413, we're ready for you now. Hello?
Hello.
Hello?
Hello.
Hello, sir. Yes, sir.
Hello. Can you hear
We
me?
can hear you, sir.
Okay. Hi. My name is Harsha.
Go ahead.
I have my H-1B visa. I used my initial 6 years period of H-1B visa, and through my current employer, I had my I-140 approved with the PERM and everything and all. So my current situation is this. The kind of work that I do is a kind of like a staffing company where they keep searching for you new clients to keep working. So if I do not find any new client in the next 1 or 2 months, it's kind of like a job loss situation. So my question is, I'm just thinking of the worst case scenario, the current market conditions. What if I couldn't find any job, and if I'm looking for a job, like let's say if I've gone to India and I want to come back after a year or two, since I have my I-140 approved with my current employer, I just want to know the pros and cons of going with that thought approach when you want to come back at a later time for a job. And yeah, I just want to understand that details regarding that.
Sure. Yeah, so now that you have the I-140 approved and you've been counted in the lottery, if you do end up relocating to India for a period of time, and in the future you have a job offer from a company that is willing to file the H-1B for you, it's very easy to come back. They just would file the application for you in consular processing. Once it is approved, you would need to get the visa from the consulate. If you don't have a valid H-1B visa in your passport at that time, you would need to go to the consulate and get an H-1B visa. But once you've done that, then you can come into the U.S. and continue working. The company can file the H-1B for 3 years for you based on your I-140 approval. Yeah, and you don't have to go through the lottery because you've already been counted once before.
Because I have my I-140, this whole thing is enabled.
Yes, yeah.
All right. Thank you, sir. Thank you so much for calling. All right, let's take our next caller. Caller with number ending in 3363. 3363, we're ready for you now. Hello? Caller with number ending in 3363. We're ready for you. Hello?
Can you hear me now?
Hi, sir. Yes, we can hear you, sir. Thank
Hello?
you for calling. Let's go ahead with your questions, sir.
Yeah. Yeah. Hi. I have a question regarding my travel plan to India. So my stamping on my passport is till July 15th of this year. And I recently filed for approval, and for H1 extension, and it got approved till 2027.
Okay.
So, and I'm planning to travel to India, probably end of May and come back by June 15. While my stamping is valid till July 15. So is it safe to travel with 1 month, 1 month of visa validity on passport?
Yes, that's fine. So when you are coming back, you just need to make sure that you have your approval notice that has an end date of July 2024, as well as the most recent approval notice with the 2027 end date, and show both of them to the officer at the border along with your H-1B visa stamp. The officer, based on that, is supposed to give you the I-94 valid until 2027 if it's an extension with the same company. So they're supposed to give you until 2027. There shouldn't be any problem with that. Every once in a while, we hear of CBP officers making a mistake or not understanding the policy and only giving you the approval until like July 2024 for only a month on the current approval notice. If they do that for some reason, so just make sure to check your I-94 online once you are in the US. If it doesn't say 2027, then try to go back to or email deferred inspection to ask them to make the correction.
Okay, I need to reach out to some officials in
So it's called deferred
USA?
inspection. So CBP deferred inspection. They're the office that is supposed to kind of deal with I-94 errors. They usually have a physical office in all the major cities, but the easier way that we found and kind of the safer way that we found is to just email the CBP office. And if you Google CBP deferred inspection, it will come up with a list of all the deferred inspection offices with their contact information. You don't have to email the deferred inspection office of the city that you came through. You can actually, technically you can email any deferred inspection office. So if you entered in Los Angeles and they gave you the wrong I-94, you can email the CBP office in Atlanta or New York and have them fix it. Because different deferred inspection offices have different policies. Some of them, for example, Houston, where we are, they are very unhelpful. They don't accept any correction requests by email. They require people that if they're asking Houston deferred inspection for a correction, they require you to come in person on they're only open certain days between certain hours. And then even if you do that, they are not that helpful in person. And so for our clients who come through Houston, if they need an I-94 correction, I will usually email a different port of entry, like New York, that is more helpful.
Interesting.
Okay, so I mean, at the port of entry, if I inform them that I have another approved H-1B with I-94 on the I-797 till 27, will that help?
It should. I mean, yeah. So you should hand the officer both approval notices so that they see that you have an approval notice until July 2024 and it's already extended until July 2027. So make sure you hand over both.
Okay. Thank you, sir. Thank you so much for calling us. Okay, let's take our next caller. Okay, caller with number ending in 4229. 4229, we're ready for you now. Hello? So please press *6 to unmute your line. *6 to unmute your line.
Hello.
Hello?
Can you hear me?
Yes, sir, we can hear you, sir. Go ahead, sir.
Yeah. So currently I'm on STEM OPT and my employer will file for my H1 lottery. But I have a question regarding a victim visa. So in 2019, one mugging incident happened with me and I got stitches and everything. And I have a report for that also and police report. So will I be eligible to get that visa now also, or like if yes, then what does the path look like for that?
Okay, so I will say that the V visa for victims of crimes in the US or those types of visas is not my specialty. I have some awareness of it, but definitely it's not our main practice area. So I would definitely consult with an attorney local to you that specializes in that area. But if you are eligible for that visa, then you do typically receive an EAD, and that would allow you to work. In parallel, though, if your company, like you said, is planning to apply for you in the H-1B lottery this month, I would still have the company do that, because if for whatever reason the change of status to the V visa doesn't work out, you may still need the H-1B change of status, and registering you in the lottery doesn't, as far as I know, affect your eligibility for the V visa. If you meet the requirements for the V visa, it's mainly based on, the circumstances involving the incident, from what I understand. It doesn't, if you're being registered in the H-1B lottery, that shouldn't affect your eligibility for that. And at a certain point, if you are selected in the H-1B lottery, you may need to make a decision about which visa to go with, so that because both of them would be a change of status. You don't want them to overlap and cancel each other out. So if possible, yeah, I would probably still have your company register you in the lottery this month if they are willing to, and then consult separately with an attorney that specializes in victim visas and that sort of thing to get an idea of your eligibility for that.
Oh, okay. Okay. Thank you. Thank you for the information. Thank you.
Sure. Thank you, sir. Thank you so much for calling us. Let's take our next caller. Okay. Caller number ending in 4788. 4788. We're ready for you now. Hello?
Hello, are you able to hear me?
Hi, sir. Yes, sir. We can hear you, sir. Thank you for calling us. Go ahead with your questions, sir.
Hi. Thanks for taking my call, I have one question. Last week I discussed. So what is the process of updating the date of birth in? Do we need to update in H1 document? Do we need to inform to USCIS if there is a change in the date of birth?
Do you mean that in the H-1B application that got filed, you realized that they listed your date of birth wrong, or is it incorrect on the I-797 approval notice?
No, I mean, basically my birth certificate is in July, but since long we are using on the passport and H1s and everything as June. So there is a month change. So we have not observed that. When we took a birth certificate from the municipality, that's where we found there is a month difference.
Okay. Yeah, I would
Can you
say
please
maybe
elaborate the steps?
For an H-1B that is already filed or approved, I would say if the date of birth that's listed on the approval notice matches your passport, then at this time I would say it might be fine. The main point where any discrepancies in your date of birth become very significant is mostly at the adjustment of status stage at the I-485, because you have to submit.
I'm talking about that time. So I'm just wanted to make sure my birth certificate is on hand for my spouse at the time. So that's where I'm getting ready for that.
Okay. I would recommend, so for the most part, USCIS goes by the passport details. So if you know now that your birth certificate date of birth doesn't match what is in your passport, I would go through the steps to try to get your passport updated with your correct date of birth, and then use that passport and that date of birth in immigration applications going forward from now. I don't think USCIS will, especially for H-1B applications, H-4 applications, I-765 applications, the difference in the date of birth won't be a problem for USCIS. They'll just verify the date of birth that's in the form based on if it matches the passport that you're submitting with it. So at the adjustment of status phase, though, I would probably include a brief explanation that some of your prior immigration forms and documents included the incorrect date of birth, a discrepancy, but that it was corrected on so-and-so date, and here's the correct birth certificate and the updated passport.
Okay, so I mean, henceforth, we need to make sure that date of birth is matching with the new date of birth after embassy corrected in passport, correct?
Yes, yeah. I don't think it's necessary to try to
Okay.
go back and revise all the prior approval notices. And I don't think actually USCIS would even issue new approval notices for
Okay.
that, but just going forward.
Okay, okay. Okay. So one more question. Like, my name is very big. It's ABCDEF, and my surname is S. Okay. But during the olden days, manual writing the passports, they moved my first name, first word A into the surname. Like now my surname has two words, like S and A, all like with the two words in the surname place, and I continued the passport in that, and my H1s and SSN, everything was like that. So when I went for my birth certificate collection, so they have only first word. So what do we need to do?
It should be fine. From our observation, it is quite common that the birth certificate or the marriage certificate, the way the name is spelled out on those certificates doesn't always match what's in the passport. It may be like you said, a partial difference or, abbreviation of part of a name in the passport or vice versa. As long as it's pretty clear that it's referring to the same person, so far we haven't seen any problems. Filling out the immigration forms, though, again, USCIS for the most part goes by what's in the passport, even if we know what's in the passport is not the most accurate way that your name is supposed to be, or even the way that you usually use your name in your own life. Unfortunately, unless you can get the passport updated, we will fill out the immigration forms, and USCIS expects the immigration forms to match the way it appears in the passport.
Okay. All right. Thank you, sir. Hope that helped you. Thank you so much for calling. Let's take our next caller. Okay, caller with number ending in 4500. 4500. We're ready for you now. Hello? Okay, while we're waiting for this caller, there's a question from Manish Parnekar. Rebecca, he says, if any student is staying in a dorm, do we need to update the address of the dorm as her address is on her, green card? And will it impact her in any way if she's going to go in for a citizenship?
Oh, technically on the N400, I would list even a dormitory because they ask for your prior residence history for 5 years. I would include the addresses of the dorms, even if it kind of is changing different semesters. As far as
but
updating,
they need to update her address on the green card.
If she has the green card, technically green card holders are supposed to update their address with USCIS. However, for USCIS, it's mainly updating the green card is more for mailing purposes. So if her address that was on her I-485 application when she got the green card was her parents' address where they're still receiving mail, it's probably not necessary to update the address right now, but later when filling out the citizenship application, I would list the actual dorm addresses in the prior residence history.
Got it. Because they're a little bit doubtful about whether she'll continue to receive her mail at a dorm. But thank you for that clarification. Let's take our caller. Caller with number ending in 4500. We're ready for you now. Hello?
Hey, hi Nitya, can you hear me?
Hi, sir. Yes, we can hear you, sir. Thank you for calling us. Go ahead, please.
Hey, thank you, Nitya. And hi, Nitya and Rebecca. So quick question here is, right, so I have a 485 interview next week. And initially in 2020, I did file my 485 with employer A. And after 180 days, I moved to employer B. And now, like for my next week's interview, my employer B is a full-time job, but they declined giving me like 485J, and they don't want to. And they said that they can provide the offer letter and like employment verification letter, but they don't want to sign it. And I asked that attorney, like, what is the specific reason why you don't want to sign it? And they didn't give me any specific explanation. The only explanation what they gave me is like, we can sign the 485J if we filed like your 485 before. So they declined it. Now the question is, for the next week's interview, I was looking around and I found a job, but that's a small company though. And in the same basis, like I don't want to leave my current job as well. And other job with the employer, see, it's a small consulting firm actually, which is like, employees below 10, and they are implementing a small product as well. And possibly I might be joining them in 3 weeks. Now the question is, when in the interview, can I take my employer fees like 485J? Will that be a problem if it is a consulting company?
Let's see. So in the interview notice, did it mention that that USCIS wants you to bring in a J supplement from your current employer? Or did you ever get an RFE asking for the J supplement of your current employer?
Interview notice is saying that like I need to get a 485J.
Okay, it's saying that you should bring a 485J supplement from your current employer?
Yes. It didn't mention that, it said like if you change the job, like you have to get a 485J. It didn't mention that it's from the company.
Okay. I don't think it's necessarily for you to change your job just for the purpose of having an I-485J. If your current company has an employment verification letter, because that's basically what the J supplement is. I don't know why your company isn't willing to give you the J supplement. I mean, it's not necessary that they have filed the I-485 for you in order for them to issue the I-485J, but essentially the J supplement is just an employment verification letter in an immigration form. Basically, the information the J supplement asks from the employer is verification of your job title, your duties, your salary, that you're full-time, the company's tax ID number. So if you have an employment verification letter, if you can ask your company if they can provide all the other information that would be in a J supplement in their verification letter, like title, duties, your salary, that you're full-time, their FEIN, the size of the company's address. If it's on letterhead, then it'll have the company's address and contact information on there. And if the employment verification letter is signed, that is essentially the same function as the J supplement. So I would probably try, if the interview is next week, like you said, I mean, there isn't enough time even to switch to a new employer. And I don't think you should have to, just for the purposes of getting a J supplement. I would try to go to the interview with an employment, ask your current company if they're not willing to provide a J supplement for whatever reason, make sure that your employment verification letter has all the information the J supplement asks for and is signed on the company's letterhead. And if you go in with that, I would think that the officer would be fine with that because it serves essentially the same function.
Yeah, the problem here is, right, it is the large corporation, and usually they won't provide that. They have a standard template. We will just get.
Does the template include your title and salary and all the details of your employment?
Yeah.
Okay. Yeah, I mean, the main purpose of the J supplement from USCIS's side is to confirm your start date and that you're employed in a same or similar occupation to the one described in the I-140. So if they can tell that from the employment verification letter, I would say that that should be enough. If for some reason...
Is there any problem, I was planning to take a new opportunity as well, right? I don't want to leave the current opportunity, and I was planning to take the new opportunity as well. It's a consulting company, and they do have a product. It's a small company though, which is the employee strength is below 10. So this is where the question is: if I give that 485J and if I tell him that I'm moving towards this employer, will that be a...
I mean, if you are planning to change anyway, and you can do it before the interview, then technically that's fine. But I don't think it is necessary, really. If you go to the interview and for some reason the employment verification letter from your current employer is not sufficient, they'll send an RFE with you, and then you can go back to your current company and show them the RFE that's asking for the J supplement. If they're still not willing to, then maybe you can consider moving to another company at that point.
Okay, got it.
All right. Thank you, sir.
Okay,
Thank you so
yes,
much for joining
that's
us.
it. Thank you. Thank you very much.
Okay. All right. Let's take
Thank
our
you.
next caller. Yeah. Hey, caller with number ending in 9461. 9461. We ready for you now? Hello?
Yeah, I'm ready.
Yes, sir?
Can you hear
Yeah,
me?
go ahead, sir. We can hear you now. Go ahead, sir. Please.
Yeah. Hi. Good evening, Rebecca. So
Hi.
my question is, I'm on H-1B status. I have approved I-140 in EB2, and my wife has I-140 in EB1. Currently, she is working in India. So my question is, I'm planning to go to India, like take a break for 2 to 3 years without working. Planning to come back to US once the dates are current. So here my question is, will there be any problem if I come back when the EB1 dates are current, and we are planning to come back on H1 and H4 status if dates are current? So will that be any problem for my H1 extension, or if I take a break, or what is your suggestions, please?
That should be fine. So when the EB1 dates are current, so would your wife be coming back in H-1B and you would come in H-4?
No. She will be coming on H4 and I will be coming on H1.
Okay. Yeah, as long as you have a company at that point that is willing to file your H-1B in consular processing,
Okay.
then yeah, that's fine. Mhm.
So it doesn't affect, like, if it breaks the continuous process for H1 extension and all those things, it doesn't affect my further 485 process?
Not for you, because in this situation, the two of you would be filing the I-485 based on your wife's EB1 I-140. So that continuity of a job offer isn't needed for you. Technically, it's, if she has the EB1A, if it's self-petitioned, she doesn't even technically need, an employer job offer the entire time because it's self-petitioned, as long as she is still...
She has EB1C.
Okay. Is her company, willing to sign a J supplement, like 3 or 4 years from now for the I-485?
Yeah, you mean like, they will do the process from,
Okay.
they will do the process for that 485 process, yeah.
Okay. Yeah, then
So there will be no, okay, go ahead.
Oh, I was just going to say, then the interruption or the gap sort of in your employment won't be a problem, because they'll be looking mainly at her employment with her EB1C sponsoring company. And as long as the company is supporting the application at that time, that's all that's needed.
Okay, and like, quick question, like, my employer, they have branch in India and they have branch in US. If I'm planning to go, what is your recommendation? Can I work in India or take a break? I have like a couple of options, so that is the reason I'm asking. They have branch in India also. It's better to...
Either is fine. If you are planning to work, then it sounds like your company can, employ you there, but it's not necessary, since you would be filing the I-485 as the derivative family member. There isn't any employment requirement on your side at all of maintaining sort of employment or a job offer. That would only be needed if you were filing the I-485 based on your EB2.
Hello? Okay, I guess he's gone on mute, but all right. Let's take our next caller. Okay. Caller with number ending in 7088. 7088. We're ready for you now. Hello?
Yeah. Hi, Nitya.
Hi. Thank you for calling us. Please go ahead with the question.
Can you hear me?
We can hear you. We can definitely
Thank
hear
you. Actually, yeah. On H-1B, when we are entering US for the first time, can we have a joining date of the company 2 weeks after we enter the US, or should better to join immediately?
It's better to join earlier rather than later. I think the kind of the time frame is about 10 days. So generally for H-1Bs, for example, if you're coming in for the first time with a October 1st start date, CBP allows you to enter anytime after September 20th. So you have 10 days to be in the US to kind of get settled before you actually start work. So I would try to keep it to kind of that 10-day time frame.
Okay, suppose if we are entering after October 1st, I mean, after we have a valid visa, if we are entering like October 10th, can we take 2-week break and then join?
I would try to still keep it within those 10 days since it's since that's what the government has kind of allowed for. Yeah, if possible.
Yeah. Okay, thanks.
Thank you, ma'am. Thank you so much for calling us.
Yeah. Thank you.
Thank you. I know we have a lot of people on the live chat as well as on our callers list waiting to talk to Rebecca today, but unfortunately, how much ever we try, we keep running out of time for this show. Rebecca, thank you so much for being on the show today and for helping all our listeners and our callers as well. We really appreciate that.
Yeah, thank you for having me. It's always a pleasure.
Sure. And to all our viewers on Telugu, we look forward to seeing you same time, same place next week. Bring us your questions, bring us your calls. We love to hear from you. We always love clarity. So please try and call us whenever possible so we can try to get through as many. And we take leave for this week. Have a safe and happy week. Bye.